Good morning, folks. Thanks for coming to what is now the 76th NYU Annual Conference on Labor. We got started when the Taft-Hartley Act was enacted, and we're still going strong. Today's theme is a little, latitudinous. It's challenges and opportunities, because it leaves a lot of room for our creative invention and intervention. That's why we chose it. So glad that Solicitor of Labor is back. I think it's her third appearance as one of our keynote speakers to the conference. She's been a tremendously energetic Solicitor of Labor, which is a very important position. And it's my job to introduce, first of all, I want to thank all of the people here. You can't hear me? I want to thank all the people here who make this possible, most especially Allison Schaffini and Caitlin Villanova, whom you will get to know if you haven't already. Also the members of our advisory board, of which Mark is one, who keep us afloat and participate in our activities, and also the sponsors of the conference, who are listed on the brochure. It's now my pleasure to introduce Mark Brossman, Schulte Roth. Mark is one of the co-leaders of the labor employment practice. He's also developed a higher education practice. I don't know if you call it that, do you? Yeah. A higher education practice. And of course, since higher education is one of the truly well-funded institutions in this country, they can afford the services of a Schulte Roth, finally. It's been an achievement for them. Of course, they've been the center of many controversies, and Mark is the fellow to go to. In labor and employment law, he covered the gamut of issues, but he's been predominantly at least historically, he's been predominantly in the ERISA area, in the employee benefits area. Mark is a person, this is a very contentious field. It's always been a contentious field. Don't let anyone tell you it's only become a contentious field. It's always been a contentious field. And it needs to be, because it's about a fundamental division of interest in the society. Not an unbridgeable division of interest, but a fundamental division of interest. And Mark is one of these, I think, relatively rare lawyers that has been able to be an important and acceptable interlocutor for all sides. He's a man of integrity and vision, and he's a member of our advisory board. I'm very pleased that he's here today to do the duty of introducing our speaker.
I didn't deserve that or expect it, but I appreciate it very much. You all didn't see Sam was holding my hand under the table.
Hoping he would not bolt.
I'm hoping that's not harassment. It's not. It was welcome. It's all fine. I appreciate it.
See how well he knows his employer.
I'm honored to be here at the NYU Conference of Labor, which is one of the great events in labor law in the city. The speakers throughout the whole conference are a who's who of one of the great lawyers in our area, both in New York City and nationally. So I'm happy to sort of kick off by having the honor of introducing our keynote speaker this morning. Seema Nanda, the U.S. Solicitor of Labor. I've never met Seema before, and I told her before we started that she has one of the most interesting backgrounds that I've ever seen for somebody in a governmental position. Like most of us, most of those lawyers in the room, she started as an associate in private practice and worked at a law firm till 2000, and then said, I had it, and moved on. And she's then spent a bunch of years, or a few years, at the NLRB as a supervising attorney. Then moved to the Office of Immigrant and Employee Rights section of the U.S. Justice Department Civil Rights Division, where she was a senior trial attorney and then deputy special counsel. In 2013, she joined the U.S. Department of Labor during the Obama administration and held various roles, including Chief of Staff, Deputy Solicitor, Deputy Chief of Staff, and Senior Advisor to the Secretary. Between July 2018 and May 2020, she was CEO of the Democratic National Committee. In 2020 to 2021, she was a fellow at the Harvard Law School Labor and Work-Life Program, which I didn't know about and looked up. It was actually really fascinating. I don't know why NYU doesn't have something
Me too. I know
comparable,
what you're referring to.
but quite fascinating position. And in 2021, became the U.S. Solicitor of Labor, nominated by President Biden, and she's the first Indian American to serve in that role. I didn't know a lot about what the Solicitor of Labor does, and so, but it's really an incredibly broad mandate to enforce over 180 federal statutes and their implementing regulations. And what the enforcement mandate, which I'm sure will be initiatives, which I'm sure will be part of the conversation, is for her is to provide legal services necessary to help achieve the department's goals of promoting the welfare of wage earners, job seekers, and retirees. That's basically everybody. Improving working conditions, advancing opportunities for profitable employment, and providing and protecting work-related benefits and rights. And they've had a lot of litigation, obviously, in the Wage and Hour, Fair Labor Standards Act area, OFCCP, Mine Safety and Health area, Employee Benefits Security Administration, OSHA, and they enforce both civil and potentially criminal penalties. A lot of litigation, a lot of injunctions, preliminary injunctions, TRO, permanent injunctions, consent judgments. It's a very active enforcement mechanism, and they're involved in many, many issues, which I think you will find fascinating. I'm particularly interested in your view on mandatory arbitration, and I look forward to hearing your remarks on that. So with that, I introduce the U.S. Solicitor of Labor, Seema Nanda.
Thank you very much, Mark, for that kind introduction. I do have some remarks a little bit later on mandatory arbitration. And thank you so much, Sam, for having me back. I always really enjoy this conference and an opportunity to address you all. So it's really a pleasure to be, I think, in my third year. So when I started at the U.S. Department of Labor just under 3 years ago, I set forth, working closely with our leadership in the regions, with our client agencies, with our staff at headquarters, some priorities for the solicitor's office with regards to enforcement in particular, with the goal of really aligning around the president's goal of empowering and protecting workers and the actual mandate of the Department of Labor, as Mark just talked about. The way I would talk about my remarks today, it was really a year filled with seeing a lot of those goals come to fruition with some really key decisions and actions that we took, and I'm going to focus my remarks around some of those accomplishments this year. Before I begin, I wanted to just take a minute to acknowledge all of the staff here from our New York regional office. If they could just stand up for a second, because I'm going to embarrass them just for 1 sec by making them stand. I won't do anything beyond that. So the reason I wanted to acknowledge them is I'm about to take credit for really the hard work that they do on the ground every day with quite limited resources. We truly have an extraordinary staff, having worked at a lot of wonderful places in the government. I think our staff at the Solicitor's Office is truly an extraordinary group of lawyers who do absolutely extraordinary work. So when I was here last year, I talked about how the Solicitor's Office has this broad mission to meet the legal demands of the department. Mark just talked about our mission, but unlike most federal at least cabinet-level agencies, we litigate the vast majority of the over 180 laws that we enforce. That is done in our 7 regional offices. We have a number of sub-regions as well. The first priority I wanted to talk about was misclassification. This has been one of the president's articulated priorities, and We have certainly broadened that to say not just misclassification of workers as independent contractors rather than employees, but also other types of practices that don't recognize when someone is in fact the employer of employees. So it could be subcontracting, it could be alter ego cases. We continue to see a large number of misclassification cases across a wide range of industries, everything from home care, janitorial, trucking, delivery, construction, personal services, restaurant industry, what we would call traditional type of occupations and industries. But we also see misclassification in newer industries, such as platform service providers. On January 10th of this year, DOL published a final rule, which became effective March 11th, 2024. So that new classification rule, as we call it, is now in effect. And what this rule does is it sets forth how to analyze whether someone is an employee or an independent contractor under the Fair Labor Standards Act. The 2024 rule also rescinds a 2021 rule that was put out in the waning days of the Trump administration and replaces it with a rule that we believe is more consistent with the Fair Labor Standards Act as interpreted by every circuit that has considered this issue. So just to ground us a little in the history, early in the Obama administration, we had at the Department of Labor, through rulemaking, attempted to rescind that 2021 rule and not replace it with a separate rule. It was a pure rescission done through rulemaking. That rescission was successfully challenged in the Eastern District of Texas. There was a decision in the spring of 2022. We did appeal that decision at the department, but that appeal was stayed by agreement of the parties pending our rulemaking. So our rulemaking, now taking us back to where we are, rule came out in January and went into effect 60 days later in March. So what does that independent contractor classification rule do? The final rule affirms that a worker is not an independent contractor if they are, as a matter of economic reality, economically dependent on an employer for work. This is the same standard broadly that the 2021 rule had applied, and that has been in our sub-regulatory guidance for many, many decades. But what our rule does is it goes back to applying a 6-factor test that the department has applied for decades, that the vast majority of circuit courts apply in some fashion. And it is a rule that we believe will reduce the risk that employees are in fact misclassified, while at the same time providing greater consistency for businesses in making sure that our rule is in fact consistent with where the courts are. It is our view that the 2021 rule did not fully comport with the text and purpose of the Fair Labor Standards Act as interpreted by the courts. Most notably, what that rule did was it designated 2 factors as core factors, control and the opportunity for profit and loss, and gave these factors greater predetermined weight in the analysis than other factors, something that no circuit court that has considered the issue has done. So throughout this rulemaking, our enforcement work in this space has continued, and now that we have the rule, it certainly will continue again. We're certainly making sure our attorneys, as well as our investigators in the Wage and Hour Division, understand where we are and how to apply the law. But it's important to recognize that misclassification cases come up really as a defense. These are the vast majority of them are overtime cases, but there also can be minimum wage cases. We're seeing quite a few cases where employers aren't paying workers for training, things like that. So it can come up in a variety of contexts, but it's really often raised as a defense. And that's why our classification work continued, because we continue to enforce the Fair Labor Standards Act, which is really the vast majority of what Wage and Hour does is in fact overtime cases. They do a lot of other things, but they do a lot of overtime work, so our work has very much continued. On the enforcement side, I wanted to highlight one misclassification case that we filed since I was here last year. Last June of 2023, we filed what we believe is the department's largest misclassification case to date. This is a case that we are out on complaint on in the Southern District of Florida. So in this case, we are alleging that a Florida-based customer service provider for major national brands like Barnes & Noble and Walgreens misclassified workers as independent contractors, denying them minimum wage and overtime pay. The company is called Arise Virtual Solutions. And what they did is they recruit workers to, quote, be their own bosses, but then subjected them to stringent work scheduling requirements, and employees had to buy their own equipment before starting work. Our investigation revealed that Arise expected workers to pay for their own mandatory training while attending courses offered through the company's proprietary software, and then failed to pay them for attendance at what often amounted to multiple weeks of required training on a particular contract. The workers this is for Mark, subject to mandatory arbitration provisions, wherein they had to waive their ability to bring FLSA claims. So the reason I mention this is one of our priorities that I talked a little bit last year was recognizing our unique role in the solicitor's office to bring these cases where workers are subject to mandatory arbitration provisions, are often classified as independent contractors, and what you have is cases that are often evading review in any systemic way for years because the private bar can't bring them. The private bar brings the vast majority of cases under the Fair Labor Standards Act. So we've been focused on making sure that the work we're doing is really strategic. This is strategic work because most other entities cannot do this work. So in this case, we are seeking back wages and liquidated damages. I will note that in terms of the private arbitration, there have been multiple favorable arbitration decisions for employees. But again, the company's practices haven't changed because these are kind of one-offs. The District of Columbia also had a settlement with this company. It looks like they don't recruit in the District of Columbia anymore, but again, the company's practices have not changed. So that is ongoing litigation. We filed a summary judgment motion just last week in that case, and we continue to litigate that case. I wanted to turn to retaliation, which has been a priority certainly for us in the solicitor's office, for the wage and hour division, and increasingly for OSHA, who we are working very closely with. And this is also priority for our sister agencies, the EEOC, the NLRB. We have engaged in a lot of coordination on this work together under our MOUs, and then also just as a good governance thing, doing outreach together both to employers as well as employees. Our strategies in the solicitor's office in particular have really focused on early interventions. So this means that when the wage and hour division, or increasingly OSHA, sees retaliation in an active case, we are looking to see whether it's appropriate for us to go in immediately, certainly by asking for cease and desist orders if we have credible facts that an employer is in fact threatening workers while our investigation is ongoing. And then if those efforts are not successful, to more informally resolve cases, seeking temporary restraining orders and preliminary injunctions. So I have very few creative ideas, but what I can do in this role is really take good ideas that have been happening and help them happen more broadly. So, when I was looking back for something the other day, I found a press release from, maybe 20 years ago where we did this. And this would happen a couple times a year. It'd be a great thing that happened. And, maybe the Boston office would do one. Maybe they do one out west. What we really focused on in this administration is getting all of our folks in the solicitor's office trained up on this, coordinating this with WageHour that did a lot of their own training, communicating this to the private bar, And so that we have essentially processes where everyone is doing it. We have templates. We do dozens of these now every year, and we think it's been really important because retaliation is so endemic. It undergirds really all low-wage work. So strategies like this are really important for protecting the most vulnerable amongst us. I wanted to mention a couple cases as examples in this work. One maybe because of where it is. We've been successful in these PI cases in places, unexpected places. We had a case out of Mississippi called Battlefish North and Magnolia Process. In this case, the employer attempted to frustrate a wage and hour investigation by intimidating their migrant workers, threatening physical harm, termination, and deportation if the workers cooperated with the department. We filed a motion for a TRO and a preliminary injunction. And I note this case also because we filed that just 2 weeks after the Wage and Hour Division first visited that work site. So that requires an enormous amount of coordination to get in early, to get the facts. I'm really proud of how we're working very closely with our client agencies to get in early when these strategies can be useful, and we were ultimately successful in that case. The second case I wanted to mention in this space is a case hot off the press. We had a decision on this case just a couple weeks ago on May 7th. This is a case out of a U.S. District Court in the District of Vermont. It's called Sue versus Bevins and Sons. This was a case where the court just denied an employer's motion to dismiss DOL's complaint in a case involving retaliation by a Vermont construction and excavation company. So in this case, our investigation into the employer's business practices led to a settlement agreement, like the vast majority of wage hour cases do. As part of that agreement, the employer agreed to pay 17 employees back wages, liquidated damages, as well as some punitive damages for the alleged discharge of one of those employees. So after a local news story reported on the DOL case, the employer posted a Facebook message that encouraged employees to Google the background. It named the employer named the employee, which the article had not done. Encourage people to Google the background of that employee and the character of him. This is an employee that the employer believed contributed to the news story. Another public Facebook message from the employer implied that the employees who received the back wages and liquidated damages under the settlement agreement had actually returned the money to the employer. We filed a complaint in that case based on those Facebook messages alleging that the employer's retaliatory actions were unlawful in that case. This case is significant, and all of my former colleagues from the NLRB are probably going, why is this significant? We do this all the time under the NLRA. The reason it's a significant case for us is there's actually very, very little case law under the Fair Labor Standards Act on the intersection of the First Amendment and retaliation. So, important case for us. The court denied the defendant's motion to dismiss, holding that an employer's speech is not protected by the First Amendment if it is an adverse employment action taken against an employee who engaged in conduct protected by the FLSA. I want to talk just for another minute about some of our work that I characterize more broadly in the retaliation space, and this is some of our work around protecting immigrant workers. One of the things that I think stymies all of us in enforcement agencies, both our federal agencies as well as state and local, is this fear of immigration-related consequences that keeps workers in the shadows, keeps them from cooperating with us, keeps them from stepping forward. A couple years ago, we developed FAQs, which are questions and answers, as we call them in the federal government, on how we can issue what we call statements of interest to support workers who are involved in labor disputes and want to seek prosecutorial discretion with the Department of Homeland Security. So what we have done through this process, and this is something that our sister agencies, the EEOC and the NLRB, are doing, several state agencies are doing this as well, is we're essentially making more transparent something that has long existed under our agreements and that have been codified over the years in MOUs with DHS. And it's essentially a process where a worker can step forward and say, hey, there is this going on at my work site, there is this fear of retaliation, there's been retaliation. And what we are doing in the agencies is saying, we're not the deciders. We don't enforce immigration law, nor do we want to. But we are saying to DHS, after evaluating it, that yes, we do think that there is an interest in this worker in potentially having an interest in whatever the underlying investigation is. The worker goes directly to DHS if they so choose from that work site to actually see the prosecutorial discretion, that we don't have insight into what happens. But I think it's another important tool amongst many of protecting most vulnerable workers. And I talked a little bit about how we're starting to move into this retaliation work in the OSHA space as well. I wanted to highlight just one case out of the district court in Connecticut, because I think this is the first case where the department filed a retaliation case asserting both violations under 11C of the OSH Act, which is the retaliation provision, as well as 15A3 of the Fair Labor Standards Act, the retaliation provision there. The employer had threatened employees who asked to be paid compensation they had earned, and then unlawfully terminated employees who participated in an OSHA inspection. In that case, we very recently, in December, had a default judgment entered granting the $360,000 in back pay, emotional distress, withheld compensation, and punitive damages. I am going to switch gears a little bit, but staying along our priority related to vulnerable workers, I can't not speak to you without talking about the child labor work that we've been doing, because it has been really an all hands on deck affair for us, and we are working very, very closely with our colleagues in the Wage and Hour Division to really build out these cases and build out a lot of new strategies, or maybe they're not so new, but fortunately or unfortunately, we haven't had to use them for many, many decades. But we have seen a great resurgence in child labor in fiscal year 2023. Department investigators identified child labor violations in 955 cases, assessing more than $8 million in penalties, which was an 83% increase over FY '22. So what do we do in the solicitor's office in these child labor cases? These are very resource intensive for us in the solicitor's office, and certainly in the Wage and Hour Division. Our work here includes pre-referral assistance, very time-sensitive motion practice, complaints, motions for TROs to stop dangerous employment of children, and efforts to ensure that the companies are not profiting off of the hot goods produced by the Fair Labor Standards Act. So we've had a commitment to using all of the tools really available to us, and are really employing them quite aggressively to stop and deter unlawful child labor. Some of these tools that we are using include motions for temporary restraining orders to stop unlawful conduct immediately and protect children who may be at risk for losing life and limb. We also support the Wage and Hour Division in the enforcement of the hot goods provision. The hot goods provision is a very powerful tool under the Fair Labor Standards Act that prohibits the shipment of hot goods where those goods are produced in an establishment in or about which oppressive child labor occurred. And I stress that in or about language because it means that you may not be the employer, but it happened perhaps in your establishment. The other powerful aspect of the hot goods provision is the goods remain hot, and they can remain hot as they travel in the supply chain. So the hot goods provision, unlike a lot of labor and employment laws, allows us to hit other aspects of the supply chain as the goods are moving through commerce. Some of the remedies that we have been seeking disgorgement of profits under the hot goods provision when appropriate. We have been seeking nationwide injunctions, so potentially getting at several hundred of an employer's facilities when we have an investigation that, with our resources, may have covered a much smaller number in the single digits. And the reason we're doing this is we really see it every hot goods action, every consent decree, every case we have as an opportunity to change behavior, improve industry practices so that we can better prevent child labor in the future. So consent judgments, for instance, can help improve practices involving supply chains, such as staffing companies. I would call our approach to these cases as layered because it's complicated and there's not sort of a magic silver bullet for this work. But some of those tactics include training for management, culturally and language appropriate training for rank and file workers that include know your rights training, provisions that require staffing companies and subcontractors to also take the same actions that an employer may be required to take. Express prohibitions on retaliation or training on retaliation, discipline for supervisors and managers who knowingly allow the children to work at the facility. We've used outside monitoring, third-party monitoring in many of these cases. Access for wage hour investigators without having to use subpoenas, civil monetary penalties, and as I mentioned, disgorgement of profits. So I wanted to mention a couple of examples of this work. In March of this year, we obtained a consent judgment against a company called Tuftork, which is a Tennessee parts manufacturer, after the wage hour division identified several children employed in dangerous jobs there. The consent judgment included a little less than $300,000 in civil penalties, and it also required the employer to set aside up to $1.5 million as disgorgement of 30 days of profits. We did thereafter calculate the exact amount of 30 days of profits related to the use of child labor. And the proceeds per that agreement would be used for the benefit of those children that had been illegally employed. The agreement also required some of the things I mentioned, third-party monitoring. It required the company to contract with a community-based organization to provide know your rights training to rank and file workers, a tip line, refraining from certain practices with staffing agencies and other contractors that have child labor. The other case I wanted to mention is a case called Moon Poultry out of California, which is one of the largest wage violation settlements ever reached with U.S. poultry workers. And in this case, a federal court in Los Angeles entered a consent judgment in April of this year that orders owners and operators to pay $4.8 million in back wages and damages to 476 workers. And the consent judgment there, similar to Tuftork, the consent decree also requires the company to disgorge $1 million in profits earned from the sale of goods tainted by oppressive child labor and to pay a penalty of $171,000 for their child labor violations. That consent decree follows the court's grant of a temporary restraining order that significantly barred the shipment of goods into commerce and required the company to disgorge all profits related to such shipment. So this disgorgement remedy really recognizes that no employer should, in fact, be profiting off the shipment of contraband and off the backs of children. Our child labor work continues. I could talk on and on about it, but I had a few other things I wanted to cover. The last thing I would just say on child labor is we've also had a great focus in ensuring that we are holding all potential employers accountable. So this means that we are certainly working with Wage and Hour in our investigations with the complicated arrangement that exists in employment relationships today. We are looking with host employers, staffing companies, subcontracting arrangements where companies may own a large percentage of another company. We are looking all of that very closely to see who are all the potential employers in that situation. I'm going to mention very quickly a couple of rules because I know you have others probably talking a lot about our rulemaking. But a couple rules that were very recently published, big spurt of activity in April. One is a rule under the H-2A program. What this rule does, the H-2A program is the temporary visa program for agricultural workers. This rule expands a range of activities protected by the anti-retaliation provision for workers not protected by the National Labor Relations Act. The rule protects workers' choice to engage in self-organization or concerted activities, and as well as to decline attending employer-sponsored mandatory meetings where employers are discouraged from joining unions, sometimes referred to as captive audience meetings. Under the rule, workers also may now invite or accept guests at their employer-furnished housing, which would include labor organizations, service providers, or others. And the rule also clarifies what is the for-cause termination, which actually already exists in the law under the H-2A program, and includes a requirement that under this for-cause provision that employers, in most cases, carry out a transparent application of a system of progressive discipline. And very quickly, I'll mention the overtime rule, which I know has been much anticipated and much discussed about it, but our overtime rule was published on April 23rd. This is sometimes known as the white-collar exemption. Our overtime rule essentially takes on only one of the three requirements of the overtime rule, which is the salary level. There are really two key dates to remember. As of July 1st, 2024, the weekly standard salary level will increase from $684 per week to $844 per week. And these July 1st updates are under the existing methodology from the department's 2019 overtime rule, published in the last administration. And then on January 1st, 2025, a new methodology for calculating these levels will apply that will increase the weekly salary level to $1,128. And the last thing to mention about the overtime rule is that we have a commitment to update the rule on a regular basis, which we think will provide more predictability both for workers as well as the regulated community. And the rule provides that every 3 years, following that first update on July 1st, 2027, the salary level will be updated with applying the methodology in effect at that time. I'm speeding through rules, but I will just mention also that we also finalized what is called the Retirement Security Rule. This is a rule that is aimed at protecting millions of workers who are saving from retirement from being able to rely on the trusted professionals on how they invest in their savings. So what this rule does is it updates the definition of an investment advice fiduciary, the fiduciary standard under ERISA and the Internal Revenue Code. The existing rule was written in 1975 when IRAs were quite uncommon. 401ks doesn't exist. I'll just mention one critical thing that this rule does is it closes a loophole from the prior rule that prevented one-time advice like making a recommendation to roll over retirement savings from a workplace account into an IRA, which might be the most significant decision that anyone ever makes in their thinking about their retirement funding. And this new rule would cover that. And the rule was drafted really taking into account the other sort of actions that have taken place since we last engaged in this rulemaking during the Obama administration. There was a prior rule that had been struck down by the Fifth Circuit, and it also carefully takes into account that Fifth Circuit decision. I'm going to skip the walk-around rule, but because I think I heard that you have someone else talking about it, but it's also a very...
I don't think so.
You don't think so? You want me to talk about walk-around?
We've got some time.
Okay. I can talk all day, Sam. Sorry, I don't want to get you off.
We'd love to hear you all day.
I thought your chatter was, oh my God, she's taking too long. Okay.
We were chatting about baseball, so.
Okay.
Baseball scores.
Hope I'm keeping someone else engaged here. These. At the end of March, we published a final rule clarifying the rights of employees to authorize a representative of their choosing to accompany OSHA compliance officers during an inspection of their workplace. So what is a walk-around representative? So the role of a walk-around representative is an employer can have them, workers can have them, but they're really to aid in OSHA's physical inspection of a workplace. So the walk-around representative might participate in the opening, closing conferences, as well as participate when the rep is actually doing their physical inspection. They can aid various ways, explaining equipment processes, policies and procedures, providing interpretation. We took on this rulemaking because there was a 2017 court decision that found that OSHA's practice of permitting non-employees to be employee walk-around representatives, and our practice was articulated in a letter that we had issued during the Obama administration called the Salomon Letter. But we had a practice, as articulated in this letter, of allowing non-employees to be walk-around representatives. And the court found that that was a valid interpretation of the OSH Act, but was not consistent with DOL's regulations as then written. So what this rulemaking does is says that now, consistent with the statute, workers may authorize another employee to serve as a representative, or they may select a non-employee. And it clarifies that a non-employee rep has to be reasonably necessary to the conduct of an effective and thorough inspection based on the skills, knowledge, or experience. So it is our belief that this rule better aligns with OSHA's regulation, as well as it aligns OSHA's regulations better with the OSH Act. I believe that rule was challenged yesterday, hot off the press, somewhere in Texas. I believe
No surprise there.
the chamber and a number of other employers are in that lawsuit. I just want to note, I think it's significant that this is not a health or safety standard. It is a regulation, and it does not impose any compliance obligations on employers. The rule goes into effect on May 31st. A couple quick priority areas I want to talk about with relation to subpoena authority, because we had a couple of very significant cases, and one of our priorities has been to make sure that we are really using the tools we have in the solicitor's office to make sure that our clients, which are the Office of Labor Management Standards, OSHA, Wage Hour, can do their jobs as investigators. They are often under strict time limits to do so, and that has been a priority. Last October, we had a decision out of the U.S. District Court in the Western District of Washington that granted our petition to enforce a subpoena issued by the Office of Labor Management Standards, OLMS, to Starbucks Corporation under the Labor Management Reporting and Disclosure Act, the LMRDA. OLMS in that case was investigating whether Starbucks was required to file a financial disclosure report under the LMRDA related to expenditures on a union organizing campaign in Buffalo, New York. Starbucks raised numerous objections to the subpoena, including that OLMS changed its interpretation of the LMRDA in violation of the APA, that the subpoena infringed upon their First Amendment rights, and that the acting secretary was unconstitutionally appointed. The court rejected all of these arguments and reasoning that the merits of whether Starbucks must file a report are irrelevant at the subpoena enforcement stage, and also holding that the acting secretary had constitutional authority to pursue the subpoena. And Starbucks was ordered to produce those documents within 14 days. I will mention one other case because it came out 2 days ago, and it is thanks to the great work of our colleagues in the New York RSAL. This is a case called Dish Network, and it is an access case under OFCCP law. So in this case, OFCCP, which enforces it enforces anti-discrimination provisions and affirmative action provisions for federal contractors, and they start that work by asking for information from employers. This is an employer who has refused for many, many years to provide information to OFCCP under a variety of theories. We had sued them under the expedited procedures that are available to us through the ALJ process, and trying to get these documents. In a very significant decision, we received a decision from the ALJ rejecting Dish Network's attempts to remove the case from the expedited process, and finding that even though, regardless of when the underlying facts occurred and when OFCCP's investigation started, they still had to produce the documents, and ordering discovery to commence immediately. And so a very good decision for us in terms of being able to do our work at the department. So last, I wanted to talk about some positive developments, other positive developments in the law, and this is really for my friends, Mark and Sam, to talk a little bit more about some of our both mandatory arbitration work and other work where we see contractual provisions that we believe either thwart our ability to do our work and investigate cases, have workers come forward to us, or in fact thwart a potential private litigation. We filed a case again out of the New York region in a case called Advanced Care, which is a healthcare staffing company in Brooklyn. Before I talk specifically about Advanced Care and again some of the great work they're doing in the New York RSAL, I just wanted to talk a little bit about some of the ways these contractual provisions actually can take place. We sometimes see these provisions in overly broad confidentiality agreements that keep workers from reporting violations to enforcement agencies, including DOL. For instance, we have seen contractual provisions where workers are required to go to the company and report it on health and safety violations before they go to OSHA, which we strongly believe is unlawful, and we'll be litigating in that area. We've also seen provisions that require workers to pay exorbitant damages to employees if they leave their jobs before a specified period of time. And we've seen provisions that require the repayment of training that was for the benefit of the employer and other damages if a worker leaves their job before a set period of time, sometimes referred to as trap agreements. And we have also seen provisions that require workers to waive their rights under the Fair Labor Standards Act, which is clearly unlawful. And we are also concerned about broad indemnification provisions that can dissuade employees from actually exercising their rights under various laws that we enforce. So now to highlight Advance Care, this is this healthcare staffing company in Brooklyn. In this case came to our attention by some advocates who are actually bringing private litigation, but a worker who came over to the country from the Philippines had a provision in his contracts. He was subject to mandatory arbitration, and he also had a provision that he would have to pay the company future profits plus attorney's fees and arbitration costs if he left his job before a 3-year contractual term. So we filed a lawsuit in this case that was, as a related suit, it was eventually joined with the suit by the private litigation. We are alleging in that case that the company's demands here are an illegal request for a kickback of wages, that they would bring employees pay below what is required by the Fair Labor Standards Act, by the minimum wage, and also that the refusal to pay employees their wages free and clear violates the Fair Labor Standards Act itself. On March 8th, so again, hot off the press, the district court in that case issued a favorable decision to DOL denying the defendant's motion to dismiss our complaint and agreed with DOL that lost profits, arbitration costs, and attorney's fees are categorically for the defendant's benefit, and that a policy requiring employees to repay costs that the employer incurred cannot lawfully be shifted to employees. We also filed an amicus brief in a related Second Circuit case. This is the plaintiff's case that had gone up on an issue. And there we were really challenging a provision that trying to clarify that a loser pay attorney's fee arbitration provision, like the one at issue in that case, prevents an employee from vindicating their substantive rights under the Fair Labor Standards Act and is thus unenforceable. The court issued a favorable decision there, ruling that the plaintiff workers raised a serious question as to whether the arbitration agreements can prevent him from effectively vindicating his rights. So Advance Care remains ongoing. And we are continuing to evaluate in the solicitor's office several other cases in this space. The last case I wanted to mention, I think I mentioned when I was here last year, we have ongoing litigation in the ergonomic space against Amazon that involves nearly every region in the solicitor's office. I believe 5 of our 7 regions are significantly involved in this case. And it is being led by our friends in the New York regional office who are doing significant work in this major ergonomics case. I wanted to mention we have also have a case against Amazon related to this that is on medical mismanagement. And here we are alleging that Amazon violated the OSHA Act when employees at Amazon's on-site first aid clinic sent Amazon warehouse employees with potentially serious injuries back to work instead of referring them for appropriate medical care. We received a favorable decision on a motion to dismiss from an ALJ earlier this year. And the reason I mention it is because it was a significant decision and holding that OSHA's medical services and first aid standard applied to these medical mismanagement cases for determining whether an employer acts reasonably in sending injured employees back to work without referring them to further medical services. So I know that was a lot and a quick spin through the work the work of the solicitor's office and some of the work we have been doing. But I just, in closing, want to say how proud I have been to work with such a fantastically thoughtful, creative, and certainly scrappy staff. Our resources are perhaps never what we want them to be, but they are certainly what we want them to be, or not what we want them to be right now. But I think it is another reason that we are trying to be very, very thoughtful about the cases that we do bring and the effect that they can have on the regulated community and for workers. So thank you.
Thank you.
Thank you so much. The broad scope of your activities and your department is unbelievable. I mean, really, and congratulations for the focus on vulnerable populations and all of the things that you're doing. We have time for
2 minutes.
2 minutes, so we have time for some questions, please.
Yes, you commented on child labor enforcement. I'm sure you saw.
Could you identify yourself? That's going to be real for everyone.
Sorry?
Identify yourself.
Identify
And speak
yourself.
up.
You commented briefly on the enforcement of child.
Identify yourself, please.
Beg your pardon, sir?
Identify yourself.
Your name.
Richard Bethel, Prior Cashman.
Very good.
I don't know that identification is important.
Well, it's going to be it's the norm that I'm establishing.
It helps create community.
Speaking, if I can't be heard, we have to
Trying to get the microphone.
Tess?
be able to.
Can we get it?
Thank you. There was an article that I'm sure you read this past year in the New York Times, in fact, I think it was more than one, over the situation of unaccompanied minors coming in as migrants, being sent to various parts of the country, and being used to provide overnight child labor, sometimes for very large companies. I think as a way to, in effect, repay their sponsors, support themselves, et cetera. Is this something that your division, your office, or the Wage and Hour Division has found an effective way to begin to address? Because it's clearly an outrageous situation and one that needs to be addressed. Thank you.
So thank you for that question. In terms of migrant children being involved, we have seen very vulnerable workers. We do have a task force with HHS, Education, the Department of Homeland Security. This is definitely an all-hands-on-deck affair. I talked about this from the angle of what are we doing to enforce the law, but we recognize that problems are complex, and we are working through a variety of interagency strategies to really address the issue. I will note that we see quite a few child labor cases, and again, we don't inquire about immigration status, but we obviously learn things sometimes. But we see child labor cases that involve non-immigrant children. We had a death at a lumber factory that involved a 16-year-old that is a very vulnerable worker. Sometimes these are straight-up poverty issues as well.
Time's up. 5-minute break, I think. Come
it.
back at
Well, no,
9:55.
we're moving